distilling these issues, most of these issues are interrelated. So the evidence will be cross-cutting, meaning that evidence presented to prove issue number one will have a bearing on issue number two, issue number three, all the way to the very last issue. So if you cannot present credible, cogent evidence to prove issue number one, the possibility that you will flop on these other issues are so high.
Right.
And that's what happened. For instance, look at the issue number one. It was so crucial on whether the ICT deployed by the technology deployed by the electoral body, IBC, met the constitutional threshold to guarantee free, secure, and accountable, verifiable election. So if you cannot establish that, it means that the issues touching on Form 34, issues touching on the general outcome in terms of threshold, 50% plus one, and all these other issues, they will also be affected by that outcome.
Right.
So that is what happened. Once they failed to establish the issue number one, which according to the case, to the court, was the issue now setting the stage for determination of other follow-up issues.
All right.
Once they fail to present credible evidence in the decision of the court, then to me they had already failed in these other issues. Their chances of succeeding these other issues had dramatically diminished.
But Advocate Lungwe, we have seen, Kenyans make a joke concerning, the Azimio la Umoja petition, given that when they were coming to court, they had, lorries of evidence, two lorries of evidence. And then Kenyans were somewhat convinced that, given the voluminous evidence that is being brought to court, this is quite a serious case. Therefore, it raises the question, what is the threshold of evidence in terms of conviction? Because if the two lorries of evidence amounted to nothing, then what was really their point of conviction in terms of that particular case?
You see, one thing that I think it ought to be made clear is that cases are decided on the quality, not quantity of evidence. And according to the rules of the courts, not necessarily the Supreme Court per se, once you present the evidence to the court, regardless of the quantity, the court will have to comb through and determine which evidence is relevant and which one is irrelevant. And even before it gets to relevancy and irrelevancy of evidence, it will determine which evidence is admissible and which one is not admissible based on the rules of evidence. For example, if you were to go through the judgment, realize that at a particular point, the court decried the nature of evidence that had been presented on the basis that some of the evidence was forgery, some of the evidence constituted hearsay. In fact, they went ahead to use a very unique word in the rules of evidence where we call double hearsay. And you are reporting what was reported to you by somebody who was also taking a report from somebody else. So you cannot establish the veracity or credibility of such evidence. So the quantity per se is not so much of importance when it comes to judicial process. And that's why even in judicial proceedings where evidence is adduced by witnesses who are giving oral testimony, it doesn't matter whether you have 100 witnesses or you have one. What the court will look at is the credibility of that one witness and the strength and veracity of evidence that that witness is adducing. So it did not matter whether they brought the evidence in affidavits in terms of the canters or whatnot. What mattered was what was the content of the evidence that they were presenting. And according to the court, the evidence that was presented was not strong enough to yield to the requisite constitutional threshold that would entitle the court to allow their petitions.
So it means that then, the serious legal minds failed in what is termed as the burden of proof, given that in the 9 issues, really there was nothing that they could hold on to as a success for them.
They didn't fail because, you see, I can't say that they failed, because now allow me to also to speak as an advocate. You see, we argue clients' cases, and it's usually unprofessional. Of course, it's a good practice to advise your client, but it will be unprofessional to be turning down your client's cases based on your own judgment. After all, it's not you to render the judgment. Just to go and argue the client's case. You give the client a balanced advice, but again, you be prepared to present the client's case to court so that the court can tell the client, not you, that your case is weak or your case is strong. So what they did, and I think I really need to applaud them, they really made a very powerful and passionate argument. You could see even senior counsel Julie Soweto, although she was, there were some negative remarks, or rather some portion of the judgment which touched on her credibility in a negative way, but she made a very powerful and passionate argument about her client's case. And you see, that's what we are encouraged as an advocate, as advocates. That's what we are taught to do, because you have to present your client's case in the best way possible. So they did their best. It's not the duty of the advocate to present evidence. It's the duty of the advocate to argue the evidence.
So who brings evidence in this particular case? Because it seems like, okay, the legal minds, they were ready, they had a way of convincing the court, but, you know, the evidence somewhat did not give them that, you know, a legal playing field in terms of arguing the case of the client. Who's now in the position to bring a watertight case in terms of evidence?
In terms of evidence, evidence are supposed to emanate from the parties, not advocates. So you come to me because you have a claim, so and so has wronged you. You say so and so did this to me, and this is the proof for that. So my work is to organize how the evidence that you have is presented to court. I can't go to the field to start manufacturing evidence for you. So because that is a professional misconduct.
It means it's the Raila Odinga and team and Hela Khalifa, Willis Otieno and team that were having the burden of getting the proof.
They bear the burden of proof, and they also bear the responsibility of bringing material of probative value to demonstrate why they're entitled to the right that they are claiming that they have been infringed.
So it means in this particular case, Odinga and team quite, you know, failed in terms of, you know, gathering evidence in time?
But based on the outcome, yes, based on the outcome, because now the decision, I mean, is out, and the court has said that the petitioners did not disclose a case, meaning it was the petitioner's responsibility to present evidence. Of course, as I said, advocates, we argue cases, and we argue, you can argue a case of a client, and you can also argue and present the client's evidence to support the client's case. But you cannot go out of your way to start gathering evidence on behalf of the client. That will amount to manufacturing cases for your client.
All right, still on the basis of evidence, we had Chief Justice Martha Koome said that some of the affidavits that were being presented in court were inadmissible. In the case of Celestine Anyango and Arnold Oginga, as well as John Mark Githogo, in terms of some of them were termed to have forgeries, and others were termed not to be true and lying to the court. Do those particular occasions occur where the affidavit, people have taken oath in terms of the affidavit, but it's all hearsay and not quite the truth? And what are the implications of that in terms of those who have brought those affidavits before court as the truth and nothing but the truth?
Yes. The truth of the matter is that the outcome of this presidential petition, particularly on that aspect of presentation of evidence and affidavit and whatnot, is a huge indictment on that on those advocates, for two reasons. Number one, and the court indicated quite clearly that the first mistake they did is that they put themselves in the arena of witnesses. As an advocate, it's highly and strongly discouraged to swear an affidavit on behalf of your client, especially on argumentative and disputed facts. Because in that case, you put yourself in a position whereby if the court has got time and the other side has made an application, you could be called for cross-examination by the other side to establish the veracity of the contents of those affidavits. So that was the first mistake they did. They swore those affidavits instead of allowing parties to swear the affidavits. Number two is that the contents of those affidavits were false. And they were false in a very material way, to the extent that some of them comprised of hearsay, the reported evidence, when the rules of practice are so clear and the rules of evidence are so clear that you cannot bring in hearsay. You cannot say so and so told me. You only swear an affidavit to matters which are within your knowledge. Number two, they also refer to And the court indicated that the issue of falsified evidence, the issue of forgeries, and you present a document as if it's genuine through an affidavit, when you know, or you ought to know, that document is not genuine.
Okay.
And you see now the implication of that is that that is a criminal offense, number one, under penal code, is punishable as a general law, and is applicable not only to advocates but to any other person who makes a false statement under oath when he knows that the statement is going to be used in the judicial proceedings. Number two, it's also an impeachable misconduct on an advocate.
Oh, really?
So according to the rules of practice, if you are presented before a disciplinary committee, tribunal, or committee of that, it's an impeachable offense. It's an impeachable misconduct for an advocate to engage in such practices.
So does it mean now for Celestine and Arnold, will they be, taken through criminal offenses now that, indeed it was found that they had falsified evidence and they had taken oath that indeed what they are presenting before the court was actually the truth of the matter?
It's very much possible. It's very much possible. Anyone who is desirous can pursue. And especially, you see now, for example, when it comes to an offense under the penal code, the responsibility falls on the police and the state machinery. So they can engineer an investigation and use that to bring charges against them, so they can be arraigned in an ordinary court. Another thing is that as advocates now, they could also be disciplined by the disciplinary body within the Law Society fraternity. Yes. So they stand high chances of being held to account for those impropriety and illegalities.
All right. Now, when we look into some of the orders that the court had given during the 3-day submission, is that they had said we do a scrutiny of the servers as well as the scrutiny of the ballot boxes. But in the process of that, we had a report by the Registrar of Judiciary, and also Azimio Umoja and Kenya had their own report. And in that particular case, the court took the report by the Registrar of Judiciary. What happens when you have two reports, one by the petitioner and another one by the judiciary, but it is within the same issue, say the server, within the scrutiny of the ballot boxes in 15 polling stations, which included 41 ballot boxes? What happens when you have two particular reports, and the court has to hear both sides, because one is neutral and the other of course has interest for known reasons?
So what happens in such instance, and I don't know, it was quite weird, to be honest, because you see, the reason why these parties came to court is because they could not agree on a number of issues. And if you make an application at interlocutory stage for scrutiny of certain documents, it means you have surrendered that scrutiny or power or the subsequent processes around the request that you have made to the jurisdiction of the court. So it is only the court which will order, the court will appoint its official to conduct the scrutiny, and the court's official will submit the report. And this report is deemed to be a neutral report, given that the court is not partisan. So if you are bringing in another report, it means you are adducing extra evidence on your side. And this extra evidence has to follow the procedure. But something that is so curious, I think it must have escaped my mind, I wanted to mention on that, is I will come to it when I remember it. But the point is this: the report that was prepared by registrar of the court, that was the valid report and the only report that was useful for the purpose of the determining the issues in dispute. So, and you could see, for example, I remember there was an encounter between Justice Lenaola and Senior Counsel Murgor on the same. You could see that Senior Counsel was referring to his own report, as opposed to referring to now a neutral report, which was prepared by the registrar. Another thing which I believe was also a big blow for the Azimio team is that you see, we are told as a customer in the rules of evidence is that don't ask a question whose answer you do not know. Be cautious of what you pray for. It might be granted. So what they did is that part of the evidence, and it was in an, I believe, affidavit by one of their deponents.
It was Celestine.
Yes. They marked some 41 polling stations, which they really believed that if evidence from, if scrutiny and recount was to be done in those polling stations, then the results will be in their favor and will support their case. But to their surprise and shock, when the scrutiny was done and the results were out, it was discovered that there was no discrepancies, and if there were any, it was so insignificant to affect the ultimate outcome of the presidential election. So that was a big blow on their side, because you remember the first day and I think the first and second day, they had a rough day, especially culminating into questions that were posed to them from the bench. And a lot of people were now placing reliance on the scrutiny report. They're saying, let's see, if that report discloses that there were serious discrepancies and anomalies in the tally and the outcome, then definitely our case would have been bolstered. But what happened was that when those reports were tabled, the report on ICT scrutiny and retally, it was discovered that it was quote-unquote hot air still.
It was quite a blow. Anyway, as we move from the issue of evidence, we look into one of the issues that IEBC was looking into, which the petitioners were looking into, and it's the conduct of the IEBC chairperson of Chebukati vis-a-vis the commissioners, and in this case, single out the 4 commissioners. But the court said that the commission was well in line in terms of verification, tallying, and declaration of the presidential results. But what we saw up to the last minute is wrangles in the commission, which raised question whether it was working as a divided commission vis-a-vis working as one. But the court was convinced that indeed this commission was working as one. From where you sit and looking into the ruling of the 7-judge bench, were you convinced by what the bench had to say in terms of the conduct of the commission in regards to Article 138, 4 and 10 of the Constitution?
Yes, for me, I believe I would agree with the court to a great extent, because you see, the issue here is not about the decision of the commissioners. It's not about the decision of the court. It's about the will of the people of Kenya. See, we promulgated a constitution whereby we gave it unto ourselves, and we also committed that this constitution is going to bind all of us, including state officers, including state offices. So you cannot, it's not a preserve of a commissioner or a commission for that instance to decide who becomes the president. And if you disagree, and that's why the court was very categorical, that the 11th hour rapture, boardroom rapture, cannot interfere with the free will of the people.
Yes.
And one thing which I believe is quite important also to appreciate is the fact that these commissioners worked harmoniously until so-called 11th hour. You see, they worked harmoniously, there were no complaints, and even the court went to an extra mile of bringing out the introductory remarks that the 4 commissioners, now called the 4 commissioners, made when they were giving their press release at Serena. And they indicated quite clearly that the process has been efficient, has been credible all along until that minute. And you see now, the court had to go in and try and really discover the motive and the issue in order to protect the constitution and to protect the people. Because you see, one thing that people need to understand is that the commission is not the commissioners. The 7 commissioners can decide to run away, but we still have, we have a body which is established by the constitution. The only thing we will have is that we have a vacant body. So the will of the people cannot be undermined by one commissioner or even 7 commissioners. And that's what the constitution was saying, that if you are to scan through the entire process, you realize that the process was considerably free and fair. And therefore, if these people have disagreed and we are not being told what was the genesis of disagreement, you can't use that to invalidate a process that has been largely fair.
All right, and the court, in giving their ruling that was read by Chief Justice Martha Koome, is that even as they give a summary of the ruling, they indeed indicated that the fact that it seemed that it was a divided commission, there is need for reforms within IEBC. Is that to say that in their ruling they will give a guidance in terms of changes that will be required in the commission to avoid a scenario that we witnessed with one team in Bomas, another one in Serena, one screaming opaque, another one screaming credible? Are we seeing a situation of reforms in the IEBC as is?
They will. We are going to experience a lot of radical reforms, and from a legal standpoint. And if you were to look at it, even from the little that you were given, because what they read out to us, in as much as was the ultimate determination, but to us lawyers is just a tip of the iceberg.
Okay.
So when they release the entire reasoned judgment, we believe it will be so comprehensive, and it will encompass all the possible recommendations and reforms that the Supreme Court considers important for purposes of ensuring that we have an efficient and well-oiled electoral body. But if you were to look at even for the judgment that he had, they already engineered some reforms. You could see that there's some provisions of law that were struck down. For example, there's this regulation 87, which had given the chair a lot of powers, you see, and it was not the fault of the chair to exercise those powers, because those powers are anchored in the law. The regulation is the law. So from that point, you could see Supreme Court engineering reforms. Yes. So they started by striking down such regulation and saying they are in direct conflict, they contravene express provisions of the Constitution. And from there, we now see reforms already happening.
Okay.
So, of course, now in the entire judgment, we expect them to go deeper and look into the corporate management of IBC.
Do you see them, given that it seems that the ruling sort of favored the chairperson, Wafula Chebukati, are we seeing a situation whereby these 4 dissenting commissioners might find themselves in trouble if indeed what they were saying was not the actual truth of the matter?
Of course, there is that fear and danger, and of course, some people, if you listen to a lot of commentators, are proposing maybe, if at all their dissenting move had no basis, then perhaps the most honorable thing for them is just to resign.
Okay.
Because if the Constitution has discovered that actually the entire process was not opaque as they claimed, and the Constitution has given IBC a clean bill of health, then it would be up to them to rethink their stand and their position, because you also understand that thereafter the chair of the commission gave a statement, and he said categorically that the 4 commissioners have their liberty to decide whether to go back or not to go back. So it is up to them to decide. But what I can say is that in terms of the decision at hand, their credibility has been seriously damaged, and they will have to really rethink on their position, especially when it comes to very contentious and serious issues like election results for presidential elections.
All right, it's a valid point there, Advocate Lungwe. But now we'll be having to take a short break. But once we come back, we'll be looking into the issues of the implication of the judgment in terms of our democracy, in terms of the laws that we're facing in the country, and what means when a 7-judge bench makes a unanimous decision in terms of the strength of our democracy here in the country. Stay with us. We'll be back in a moment.
Driving and riding without incidences on the road is such an amazing experience. But do you know while many road traffic crashes are avoidable, human behavior continues to be the leading cause? Speeding, lane indiscipline, drunk driving, distracted driving, failure to wear a helmet, and failure to use available pedestrian ways have been flagged by NTSA as the fatal 6 behaviors likely to lead to a fatal crash and serious injuries. As part of the Usalama Barabarani campaign, we request all road users to prevent these fatal 6 behaviors for their own safety and that of others. When driving, ensure your speed is within the stipulated limits. The road ahead is clear before overtaking. Stick to your lane. Keep left unless carefully overtaking. You're well rested if driving on long distances, and you never drink and drive. Usalama barabarani starts with you. Fika Salama. This message is brought to you by the National Transport and Safety Authority and the European Union.
Ukiwa na dukuduku la michezo, tunafungua sanduku la dukuduku kwa ufahamu zaidi. Kila danadana, mitimko, mifiatuko na harakati zote ugani, sisi ni wako mwandani. Kukurukakara zote nyanjani, haziwezi kuangaziwa zaidi ya micharazo michezoni. Mimi mwanaspoti wako matata Peter Pinches Mwaora ndakuwa na jopo lenye maarifa sufufu, nikufahamishe na nikuburudishe wewe shabiki shakiki kwa uhakiki na kindakindaki.
And you're back. Many thanks for staying with us. We're looking into the 2022 presidential petition that was kicked out by the Supreme Court judge bench, a unanimous decision by the 7-judge bench. With us is Advocate Lungwe, who is sort of giving us a perspective concerning that particular petition. In this particular segment, we'll be looking into the implication of that judgment to the electoral laws that we have here in the country, as well as the different institutions here in the country. All right, now Advocate Lungwe, let's go back to the decision by the 7-judge bench to make it unanimous. Some of the electoral experts as well as political pundits have given the opinion that the 7-judge bench making a decision in terms of these electoral issues is wielding too much power on 7 people, quote unquote, or 6 people, or 3-judge bench if it's so, but a 7-judge bench that it is. We are wielding too much power on 7 people to the extent that now we are talking about the political career of Azimio la Umoja leader Raila Odinga, dying down because of a decision made by the 7-judge bench. Do you hold that we are wielding too much power in that institution, or is it well in line?
My opinion would be is that the court is not wielding any extra power more than what we donated to it. You see, to be a civilized society, we had to create a good forum for resolving our disputes as opposed to resorting to streets the way it happened in 2007. So in so doing, we created a special court called the Supreme Court. And this Supreme Court, we said that the Supreme Court will have a maximum of 7 judges. And the Supreme Court will have, among others, the mandate of determining whether the person who was declared by the electoral body as president-elect was validly declared or not. And if you listen to what the court said in terms of jurisdiction, what court can do and what it cannot do. The court was quite emphatic and clear that their mandate were clearly laid out in the Constitution. If you look at, for example, provisions of Article 140 and Article 163, clearly those provisions, they lay down the mandate of the Constitution, of the Supreme Court. And I believe they made that statement in reference to some prayers that had been sought by the petitioners. And some of the, of course, glaring, and striking and astonishing prayers was that the Supreme Court was to do a writ early, and if it were to find that a particular candidate who is not the president-elect actually won, it would declare that candidate. I think to that extent, then you can argue that the court was wielding a lot of power. You see, that one would mean that you go there, the court, the electoral body, people voted for candidate A, but those 7 men and women, they sit and they do what they call a retally and they declare candidate B. But what the court was quite clear on it and quite emphatic was that their mandate has been circumscribed by the Constitution. And when it is an issue revolving the presidential election, their duty is to probe into the conduct of the elections and come up with a verdict of whether the person who was declared as the president-elect was validly elected or not. And if the answer is yes, he was validly elected, then his election or her election would be affirmed. If the answer is in the negative, then the election will be nullified and we'll have fresh election. There is no room at all of retally and announcing someone who is not the president-elect. So the court was so clear, and that goes along the way, ensuring that it clearly sticks to the path that the Constitution prescribes for it, and it sticks to the mandate that were donated to it by the people of Kenya through the Constitution. So you cannot say that it's giving unto itself a lot of powers. I know some people were talking about the 7 votes. These 7 votes can only go to the extent of nullifying elections. These 7 votes cannot go to the territory or terrain of conferring victory to somebody else apart from the president-elect.
Right.
Yes, yes.
All right. When the court was talking about the case brought forward by Azimio la Umoja and other petitioners that was consolidated, when they gave their ruling is that they said the petitioners did not convince the court in terms of any illegalities or discrepancies that were there were minimal. They did not have an impact on the outcome of election, which raises the question, what is the considerable amount of votes or the considerable amount of evidence that can convince the court that indeed candidate X who was announced is not the legally elected candidate, it's candidate Y. Because even in the scrutiny of ballot boxes, it was only 1 vote that was awarded to Ruto, which belonged to Raila. So what is now the threshold of votes that can tilt the scales in terms of the winner in any election?
I think that question has been effectively answered by the decisions from the 2 petitions, the 2013 and 2017. And what the court was quite clear on was that not every irregularity, not every impropriety, not every illegality will automatically lead to nullification of an election. So, for example, if you are to take the 2017 decision, which we believe was quite groundbreaking in terms of the jurisprudence and in terms of the consequences, the declaration and the aftermath, the court was moved by the 2 aspects. You see, there is quantitative and qualitative approach. Quantitative in terms of 50% plus what, qualitative in terms of how did you attain 50% plus what. So the court focused more in 2017 on the qualitative approach, the procedure. For example, you remember during the commencement of the proceedings, the IBC was ordered to open the server, which it did not. IBC was asked to supply Form 34s, which it did not, and even those that were supplied were photocopies. And it was also discovered that even IBC made the final declaration before receiving the hard copies of some of Form 34A. So those are the things that the court took into account to say, surely, if all these things did not happen, how can we, as an independent, reasonable tribunal court, make a determination that the election was free and fair? And that's why the court reached a verdict that the election was compromised to some extent, resorting to nullification. If you look at this petition, 2022 petition, you realize that all these things IBC had rectified. For example, when they ordered for Form 34As, immediately IBC dispatched all original and certified Form 34As. When they asked for scrutiny, IBC was open to be scrutinized. When they requested for some Form 34s from specific suspicious polling stations, they were availed. And when the scrutiny and recount was done, it was realized that there were no serious errors that could warrant nullification of the election. So the court considered all those things. And that's why it got to a point whereby it said, we agree with the IBC. Because one thing that you also need to understand, we are human beings, we are not angels. So human errors are likely to be there. But the question that will be on the mind of the court would be, did these errors affect the outcome? Did they compromise the will of the people? If they did not compromise, I mean, you allow you affirm the declaration. Because some of us, you realize that even some of the agents, we are human beings. You get an agent is drunk, he just refuses to sign Form 34A. You remind some of the staff officials, they're just negligent, you see. So they fail to perform their duties to expected standards. So the court will have to look into all those things and make a determination as to whether those illegalities and irregularities really affected the ultimate verdict that was given by the electoral body.
All right. Now, when it comes to the amicus curiae or amici, depending on which school you went to, we did not see them quite, vibrant in this particular petition, though they were listed in the petition. That is ICJ, LSK, which raises the question: what is their role? What was their role in this particular presidential petition? Did they play behind the scene? Did they sit down with the judges to sort of give them their purview on that particular petition? What role did they take, given that we didn't see them during their submission?
Yes, you didn't see them vibrant, robust, or being conspicuous in court, because they, according to the rules of the court, because the Supreme Court changed the way proceedings are be conducted, appreciating that they had limited time, and these are people we are just bringing on board as friends. They are not directly involved, so we can't eat time of parties giving to people who are our friends, you see. So what the court decided is it gave them an opportunity to do written submissions. So they couldn't get a prime time to highlight the submissions or to make oral arguments, but they made written presentation, and those presentations were taken into account. If you look at the decision of the court, you realize that they have been appreciated for the contribution that they put in. But also going forward, you see, as we engage in a lot of constitutional petitions, and particularly at presidential level, you realize that some of the contentious issues which purely touch on law are getting resolved. For example, the issue of the standard of proof, the issue of whether rejected ballots should be involved. You see, those are some of the issues that amicus curiae usually engage in. But as we progress, we solidify our law and we develop greater jurisprudence, we realize that their role will continue to diminish. Because now when the dispute comes to court, you realize that most of the issues in the contention are disputed facts. And if they are disputed facts, it means that these are facts that are dependent largely on evidence and pleading. And you see the role of amici or amicus curiae cannot extend to facts and evidence and pleadings. It has to stick to the law. So as we create our law, we develop our law in the spirit of the Constitution, you realize that their role will continue to diminish.
All right, then now finally to a final question, because we're pressed on time. What will be the implication of that particular judgment? We're waiting for the full judgment in 21 days. Why did they take that long to have that particular judgment? In few words, what will be the implication of that? And why are we having Senior Counsel Murgor say that the court will have a hard time to write a judgment, given that they thwarted the issues that they raised before the court?
No, the implication is that the entire judgment is going to have to change the political landscape and legal landscape in terms of the recommendations that they're going to make. And if you are to ask me, they are going to have easier time, because they made, in as much as it was a summarized one, but a 36-page judgment cannot be, it's not too short. So at least they have a better sketch that they are going to use to formulate and come up with the final judgment. So it's a good thing. And one thing that I think it's important to mention is that every time we have these petitions and decisions, our law grows, our law develops, and even the management of our electoral affairs usually improve. So it's a good thing. We are going to see a lot of changes, especially within the IBC itself.
All right. Thank you so much, Advocate Jackson Lungu, for that particular perspective.
Thank you.
That presidential petition, and of course for making time. All right, that has been the 2022 presidential petition, of course, looking into that particular ruling and or judgment and what will be the implication of it. Of course, the DCJ, Philomena Mulu, says there will always be a winner and a loser. And a winner we had in that particular ruling, but it is not a loss for Kenyans, given that the laws that are in that particular judgment will help in our electoral laws and also to grow our political landscape as well as our democracy. My name is Irene Mwangi. I'm standing in for Dr. Ngugi Kingara. Thank you so much for making time for Law Matters. We hope that you've got a thing or two there concerning that particular petition and the judgment by the 7-judge bench, which was termed unanimous. Thanks for watching. Have a splendid night.